Okay, welcome to Labor and Health. We have quite a crowd this morning. I'd say,
I'm outnumbered for once.
yeah, there's more committee than crowd. Oh, it's changing now. So we got 3 bills before us today. First, the ground rules. If you have a cell phone, please turn it on. Cell phone goes off in this meeting, you buy us donuts for the next meeting, although somebody's cell phone went off last meeting
I don't see any donuts.
and nobody would rat them out. We don't know who it was, so there's no
It was
donuts.
a house member.
I'm pretty sure it was. I think the whole house should buy us donuts. Okay, with that in mind, Senate File 82, or House Bill 82. Representative Larson, tell us about defendant mental health illness examination amendments. The floor is yours, sir.
Thank you, Mr. Chairman, members of the committee. This bill really is a product of a conversation that we've had with this committee and with the mental health subcommittee as we've redesigned our behavioral health in prioritizing populations and those served by mental health services provided by the state. And in our conversations as we was working with the community mental health centers this year and in the subcommittee and with the judiciary, there's the concern that getting the people who have committed a crime and their time for getting evaluated and the length of time that they perhaps are spending in detention or in county jail waiting for those examinations. And one of the problems we're finding is, so let me go back up and say, so if somebody's committed a crime and they're pleading not guilty by reason of mental capacity, they're required to go and get an evaluation. They make a determination, and the determination is whether they ought to go then have an evaluation, and that evaluation can be on an outpatient or inpatient basis. And for felons, it can be an outpatient or inpatient, but most of the time that's inpatient at the state hospital. And the problem that we ran into is a lot of times we have people who've committed misdemeanors that are making a plea and are requesting an inpatient evaluation. And there's 2 downsides of this. One is that somebody who's committed a misdemeanor then goes to the state hospital, are taking up Title VII beds that we really need to have for people who've committed felons to get those evaluations. So the felons are left incarcerated, not getting the psychiatric treatments they need. And so that backs the system up. And then the other side of that is we have people who've committed misdemeanors sitting in county jails or other facilities waiting for services, and sometimes waiting longer than the sentence would have been had they just pled guilty. So what this bill's trying to do is a couple of things, and probably the most important is to say for a misdemeanor that you can get outpatient services at the state hospital, but not inpatient unless during the outpatient evaluation, it determines that inpatient is warranted. So for the most part, it would just be an outpatient basis. The second really important component of this, and it's on your bill on all of this is on page 2 of your bill, but on line 7, it talks about, but not limited to an examination of the accused at a local mental health center. So the redesign work where we've got our community mental health centers now focusing more on diversion and working with priority populations, they, for the most part, to this point, have not had forensic evaluators able to do these outpatient examinations. That's changing, and so we wanted to make sure that that stayed in place because they're now working with the other associations. We actually have the Psychiatric Association actually has in the state, we have some forensic evaluators that could work with our community mental health centers to streamline some of this, and so people could get these outpatient evaluations hopefully closer to where they're being detained or wherever, not have to make the trip to Evanston. So we think that this is also an important component in moving this whole mental health issue forward. And Mr. Chairman, that in essence is the bill.
Just a quick question for you, Representative. How many, number one is how many forensic examiners, do you know how many there are in the state available?
I want to say if Dr. Hackman was here, I think he identified that they have 4.
Okay, and that was the first part of the question. The second part of the question is, are they available, say, there's one in Casper and we needed one in Jackson, just as an example. Are they available for travel?
Thank you, Mr. Chairman. And I would just tell you that since this bill come up in the legislature, that this conversation has been taking place between that association and our Community Mental Health Provider Association, working out the possibilities of that. So I will answer the question not definitively, but hypothetically, from what they told me, that is indeed the potential there, that you would be able to, up in the northeast part of, in that Sheridan area, have evaluations, the Casper area in. And they were also willing to possibly travel to reduce the travel time from those who have committed misdemeanors or incarcerated.
Perfect. Other questions of the representative? Senator Dockstader.
Mr. Chairman, thank you. Representative Larson, this rethinking what we're doing with outpatients and misdemeanors, is this through your committee work or the mental health providers bring this to you? How did this all get started?
Thank you, Mr. Chairman. And Senator Dockstader, I think it's really a collaboration or a culmination of just the overall effort from the legislature and the Department of Health, which up to maybe this summer didn't include the judicial branch as much as we just hadn't up to this point. And it was in this conversation because the diversion that we're trying to do and the recidivism that we're trying to prevent is not just those with mental illness, but those that have mental illness that have been incarcerated. So divert them away from incarceration and having a warm handoff when they're released from incarceration. And this conversation came up just in that whole process of how we're implementing between our WAMSAC group, our Department of Health, and the judicial, and identifying, saying, that is, and so a challenge. And so if there's some way we could reduce that, we want people to get services, but we don't want people languishing in waiting for those services. And so it was kind of I think maybe it's more reflective of the silos being taken down, agencies and legislature working across the board, identifying these little tweaks that can make it easier to provide mental health services to the people that really need them.
And this is a conversation that was held, talked about in the behavioral remodel group, who's met many times. I believe we're still in that 18 months. Is that correct? I believe. Very good. Further questions for Representative Larson? Seeing none. Agencies. Go ahead.
Morning, Mr. Chairman, members of the committee. My name is Matt Petrie. I'm the Senior Administrator of the Behavioral Health Division for the Department of Health. We certainly support this bill. I think that it stands to potentially benefit everyone involved. As Representative Larson indicated, we have individuals alleged to have committed misdemeanors who will sit in a detention center until they can be seen for a competency evaluation. This has the potential to decrease that amount of time significantly. So it benefits not only those individuals that are charged with misdemeanors, but also the detention facilities themselves and the state hospital. One other thing I might add, excuse me, Mr. Chairman, is that we do currently contract with providers. Most of them are located out of state. They are licensed in Wyoming. And so we have the capacity to do this now virtually. And so with the addition of the providers that Representative Larson mentioned that are here in state, those 4 providers, that would really just complement what we currently have and would give us the opportunity to not only offer these competency evaluations virtually, but also in person for those providers that are here in state that could travel to a detention facility.
Very good. Questions, committee?
Chairman.
Go ahead, Senator
Do you see
Dockstader.
these virtual consultations increasing with time? Using them now, but do you see that being the majority of our work in the future?
Go ahead.
Mr. Chairman, Senator Dockstader, I believe so. I think we're beginning to see that is more acceptable, a more acceptable alternative. There are certainly detention facilities that are better equipped, quite frankly, to handle virtual evaluations of this type. But I think that we are seeing a move toward that. And really, even during the pandemic, we saw that where those individuals that were just seeking treatment, they weren't necessarily charged with any kind of a crime, but they were just seeking treatment. And telehealth in terms of counseling was something that the community mental health centers embraced. And I think a lot of their patients around the state did so as well. And so I think the trend is certainly moving in that direction. And I think that this is a positive step in that direction as well.
Further questions? Senator Bouchard.
Thank you, Mr. Chairman. My question is, if someone's in, let's say, Sheridan or outskirts of Wyoming somewhere, where are they going to be treated? I mean, are there treatment centers where they wouldn't necessarily be detained or have to go back to the state hospital for evaluation?
Mr. Chairman, Senator Bouchard, want to make sure that I understand your question correctly. For these individuals, they have been charged with a misdemeanor. So in most cases, they're being held in a detention facility. So the services, that competency evaluation would either occur there in the detention facility, face-to-face with, say, an in-state provider, or virtually. But again, the detainee would still be at the detention facility. We do have community mental health centers, of course, around the state. Your example, Sheridan, we certainly have a community mental health center with resources there that we contract with for mental health and substance abuse services. And so if those individuals were in need of services beyond the competency evaluation, we certainly have those resources in place.
Follow-up.
Thank you, Mr. Chairman. So the reason I'm asking the question, when I look at the language, do you have the bill in front of you?
I do.
On page 2, and between lines 10 and 12, if you look at where it says "or at the Wyoming State Hospital," and then the next line, "at the Wyoming State Hospital," if you were to draw lines on that, over that state hospital, so it would read, I'm going to start at line 9, "on an inpatient or outpatient basis at his place of detention on an outpatient basis unless the outpatient examination indicates an inpatient examination at the Wyoming, is warranted." So in other words, if we scratch that too, because I'm looking at this as the language narrows this. Whereas what if we have someone being detained in, for instance, Sheridan? That language is more specific to Wyoming State Hospital. What if you were going to run the same scenario in Sheridan without even including the state hospital? So that's why I'm asking the question.
Representative Larson, go ahead.
So, Mr. Chairman, Senator Bouchard, you're correct in that this is talking about outpatient services at the state hospital, because currently, right now, we're not providing those services at community mental health centers. And so it's saying for outpatient services, so me being in Sheridan, incarcerated, waiting for, then I would have to potentially have to make the trip, however I do that, to Evanston to get that outpatient evaluation. We're trying to streamline that. We're saying it can't be inpatient. It has to be, if you're going to get outpatient services if you're going to get services at the state hospital, it'll be outpatient. But it doesn't take away the ability of the state hospital from going to a location or providing telehealth. And it does, and that's the important part of leaving the mental health system in there, because as this whole process or transforms, it brings those evaluations closer to the person, the region that they're in, rather than potentially requiring that long-distance travel.
Follow-up, go ahead.
Thank you, Mr. Chairman. So I get what you're saying, but I'm still looking at that as the state hospitals, the tie. Whereas I'm looking at this as the community mental health center is trying to deal with this situation and want to deal with it rapidly without the state hospital. I'm trying to wrap my head around how that happens the way this language is.
Mr. Chairman, and
Go ahead.
Senator Bouchard, so starting line 6, if the accused is charged with only a misdemeanor, the order may include, but not limited to, an examination of the accused at a local mental health center on an inpatient or outpatient basis. So some of our community mental health centers can have people on an inpatient or could, but it's saying they can receive at a local mental health center or at his place of detention or or being the key word, at the state hospital on an outpatient, and we remove that inpatient component.
Okay, further questions, committee? Senator Barlow.
Thank you, Mr. Chairman. So I actually have the same phrasing bracketed in mind too. So we'll get to that later on when we have some of the, because I would like to hear what the community mental health centers have to say about inpatient. I think inpatient actually has, they have to be domiciled in some way. It just isn't you come into the office and walk out of the office, would be my view. So, but I want some of those folks to clarify what inpatient means at a community mental health center. Thank you, Mr. Chairman.
Representative Larson.
Thank you, Mr. Chairman and Representative Barlow. You're exactly right. To do an inpatient evaluation for somebody for mental illness, the physical facilities have to meet licensure and requirements, hardened, ligature issues, all of that. And of course, they couldn't take them unless they met that criteria.
Very good. Further questions, committee, before we let these folks have a more comfortable seat in the hard chair? Any further comments? Nobody, you got off the hook. Okay, go ahead and have a seat. Anybody else from agencies that wants to speak? If not, let's have organizations. Dr. Hackman, we were talking about you earlier. It's good to see you show up. We had a question specifically for you. Okay, arm wrestle and decide who's going to talk to us first.
Good morning, committee members. Andy Somerville, Executive Director for Wyoming Association of Mental Health and Substance Abuse Centers, Community Mental Health System. And so we're here to support this bill. I just want to touch on a few points in terms of questions that I've heard during the testimony. We do use telehealth quite extensively across the state. That certainly increased during the pandemic, but it's something that the community mental health system had to do and be involved in prior to the pandemic, just due to the nature and the number of providers that we have across the state. I think that'll continue to be an ongoing necessary tool, but we certainly want to make sure that we have providers as much as we can across the state. In terms of the future of community mental health systems potentially being able to step into this, we certainly see that possibility. We don't currently have forensic examiners on staff at community mental health centers because that has been reserved exclusively as a role for the state hospital, but that certainly is possible. I know myself and Dr. Hackman sitting next to me have had a few conversations already about how that might work. It certainly is an opportunity for resource development. As was stated, as behavioral health reform moves along and the community mental health centers become more involved in these types of populations, that certainly seems to be something that would be a good fit. Mr. Chairman, to the question about residential or inpatient for community mental health centers, what we're really talking about there is just the crisis stabilization facilities, the facilities that would be equipped to hold those types of clients. And I'll be clear that it is possible that we may not be able to hold all of these types of clients, depending on their level of behavior and violence or particular needs. A regional community or crisis stabilization center may not be able to hold them, but it is a possibility. But that's really the only inpatient or residential setting that we would be able to do that in. Mr. Chairman, again, we support this and happy to stand for questions.
Questions from Ms. Somerville? Go ahead, Senator Bouchard.
Thank you, Mr. Chairman. You heard my question about the language. See, my concern is, so let's say that your centers, let's say there was a line in between, or on line 10 that just goes right across there. And the scenario on the upper part of that language would handle if you had a client in one of your centers. And then below that, it would say, but if in the Wyoming State Hospital. So get where I'm going with this. I don't want to, I don't want to limit you guys from developing this, because this isn't a one size fits all, the way I see it, the way it's written. So any ideas on that? Any thoughts, or am I on a bunny trail that I just need to get out of?
Ms. Somerville.
Mr. Chairman, Senator Bouchard, I don't know that I have an answer for you. I mean, we're comfortable with the language above that. We feel like that gives the community providers the ability to do the exams. In terms of how that flows exactly at the state hospital, that's a little bit different scenario. I would imagine that if we did the exams, whether in an outpatient, whether they're at the detention center or in a residential setting, and certainly an indication of services would be necessary, that would be something that the community mental health centers would step into right away. Now, how that referral would come out if the Wyoming State Hospital does that, that's a process I think that we'll have to work. We would have to have more details and work on exactly how that referral would come back so that we could begin services, if I'm understanding your question correctly.
Okay, just quick. Oh, go ahead, follow up.
Thank you, Mr. Chairman. Yeah, that you touched on what I'm talking about. I'm worried about a fence being up and something happening and you guys can't handle it because we stuck it in law. So that's where I'm thinking. So
I have a quick question, is that we talked about forensic examiners. Tell me about the special licensure required. Tell me about the additional educational requirements. What are we talking about? What above and beyond what you have right now at the mental health centers? What kind of licensure, what kind of additional training are we talking about? And do we have any of those in the state?
Mr. Chairman, I believe we have 4 in the state, as I phone a friend next to me here. And I do believe that that is some additional special training and certification, but I would allow Dr. Hackman to speak more directly to that. We are currently looking through what changes we might need to make here in the future to accommodate more of those, either with if psychiatry is a possibility, as well as psychologists, if there are any other licensure types that might be able to work in that vein. But again, it's just not been something that we've been asked to do, so it's really going to be a resource development piece over the next year or two.
Okay. Let's throw Dr. Hackman under the limelight there.
Good morning, Mr. Chairman, members of the committee. Dr. Hollis Hackman. I'm a psychologist and I represent the Wyoming Psychological Association. And as a disclaimer up front, I am not a forensic psychologist, but folks with psychology degrees, doctoral level degrees who are licensed in the state who pursue additional training in the area of forensics are actually the folks that call themselves forensic psychologists. And we have a good half dozen here, 4 or so in this county and a couple in the county just to the west of us. Those folks travel over on a regular basis to do assessments in our jail over in this county and over DVR sometimes and other places that are possible to do a clinical interview. So we do have folks that are available, and some of this work can be done via psychological means. It depends on the extent of the assessment and what all has to be done. Sometimes intellectual assessments are required. That requires some interaction with the client. And so a proctor might need to be available to do that from a remote place, but those are all possibilities. And having provided that information, I would do my best to try to answer any questions, Mr. Chairman.
Questions for Dr. Hackman? Senator Barlow.
Thank you, Mr. Chairman. So the statement about folks traveling back and forth, we're talking about specific to Title VII and not Title 25. Is that accurate?
That is correct. Mr. Chairman, Senator Barlow, correct.
Thank you.
Okay. Very good. Further questions for Dr. Hackman? Senator Dockstader? Nope.
Ms. Somerville.
Okay.
Have you got a lot of feedback one way or another from your local providers? Involves. Yeah. Have you heard much back from your local providers?
Mr. Chairman, Senator Dockstader, I have met with all of the directors of the community mental health centers on this subject. Their initial concerns were, we can't pick this up and do it tomorrow. It's going to take some time to do some resource development to be able to, in a position to do this.
Further questions? Seeing none. Thank you very much. Anybody else here who would like to speak to this subject? Welcome to Labor and Health.
Good morning, Mr. Chairman, members of the committee. My name is Elisa Butler. I am the State Court Administrator for the Wyoming Judicial Branch. I just wanted to speak to you today and tell you that we are fully in support of anything that will get defendants out of jails more quickly. Right now, as you heard testimony, many of them are languishing in jail for minor offenses because they are awaiting competency evals. So anything that will move that process along, we fully support. And Mr. Chair, I'd be happy to answer any questions.
Questions for Ms. Butler? Seeing none. Easiest testimony today. Thank you for coming and visiting with us.
Thank you.
Anyone else in the audience wish to speak to this bill? Anybody online that wishes to speak to this bill? Must be Monday morning. Nobody wants to talk. Committee, what's your pleasure? Moved by Senator Dockstader. Move, do pass. Let's discuss this bill. We'll go through it page by page. Lloyd, yeah, Representative Larson, come and join us. Anybody see anything on page 1 they would like to change or alter? See nothing. Page 2, Senator Barlow.
Thank you, Mr. Chairman. So this goes to, I think, what Senator Bouchard is interested in, and I think I also have some. So if you look at lines 11 and 12, it seems like the only way you get to the state hospital, which I think there's an assumption in this bill that is the highest level of, I don't know if accuracy is the right word, because I don't want to disparage any other provider in the community, but that's a level of inpatient at the state hospital is, the definitive or the place of the highest level of examination or care. But when I look at this language, it's only the state hospital outpatient that could actually make that, bump them to that inpatient thing. And so I'm just as a suggestion, I'm going to suggest on line 11, you strike the patient, the outpatient, and insert an. So it would read, unless an examination, strike the rest of the sentence at the Wyoming, and then the next line, state hospital. So then it would be any examination, i.e. at a mental health center, both inpatient or outpatient, or at the detention center, indicates that an inpatient at the state hospital is warranted. Anyway, so if an examiner at the local mental health center said, I think we can do this, but I want this to go to another level. I want a psychiatrist. And that brings me back to how many are there in the state and how different than this is than in Title 25. An examiner in Title 25 versus a designated examiner in Title 7, there's only 3 individuals or 3 entities that can be a designated examiner: licensed psychiatrist, physician with forensic training, or psychologist with forensic training. Examiner in Title 25, which is, I understand, a different thing. It's a different thing, has a whole list of folks that can do this. So I guess what I'm trying to say is that, anyway, so there's a difference in the examiner, no question, and I understand that, but it seems like we're only giving one path to get to the state hospital as an inpatient, and that is they had an outpatient by the state hospital. Thank you, Mr. Chairman.
Comments? Representative, go ahead.
Mr. Chairman, Representative Barlow, I concur with that observation. I would suggest maybe a different approach to correct it would be on line 11, strike at the Wyoming, and on 12, state hospital. And so then it would read that unless the outpatient examination indicates an inpatient examination at the Wyoming State Hospital is warranted. And so then that would say, that would tie in everything up above, and then, you know, that outpatient examination indicates an inpatient examination is warranted, then it could be done. So it's not limiting the outpatient examination that determines if an inpatient examination can take place. It can be from any of those examinations that you're talking. Am I saying that right?
Senator Barlow.
Thank you, Mr. Chairman. So, and I appreciate what you're doing is leaving the outpatient in. And so would we say that can we get rid of the line 13 language is saying the Wyoming State Hospital there? If an outpatient says they need an inpatient, doesn't matter where it's held. That's my question.
Fair enough, Mr. Chairman, fair enough. Yeah.
Okay. So
Thank you.
read that to us as it would read, Senator Barlow.
Well, I think if we combine the two, the entirety of it, it would read I'm starting on line 11, basis, comma, unless the outpatient, I think it should still be unless an outpatient examination indicates that an inpatient examination is warranted.
Yeah. Yeah.
I would agree, and I would agree with, instead of it's and, I agree. Committee comments?
Mr. Chairman, and I think that does two things. I think it satisfies the concern that Senator Bouchard had about we're fencing out community mental health centers or the, other places where this could occur. And basically it's saying, look, if your outpatients indicates we need more time in place, then we're going to go to an inpatient, wherever that is. And maybe we're messing up your bill. I don't.
No, I don't think so. I think what we've based is all inpatient historically and up to this point has been at the state hospital. But as we move forward, that doesn't mean that all inpatient evaluations have to be at the state hospital. If somebody else develops an inpatient capacity, if they don't have the capacity, then that'll be the default anyway.
Thank you. Thank you, Mr. Chairman. So, Mr. Chairman, so I would move, we moved the bill, didn't we? So I move the amendment to strike replace it with line 11, strike at the Wyoming State Hospital, 11 into 12, and then strike the same language at the Wyoming State Hospital, 12 into 13. So the remainder is now, unless an outpatient examination indicates that an inpatient examination is warranted, period.
Did you get that? Okay. Committee comments?
Staff get it.
Yeah, she got it. Okay, let's vote on it. We're moving on Senator Barlow's amendment on lines 11, 12, and 13. All those in favor say aye. Aye. Opposed, say no. That amendment is adopted by the committee. Further amendments, suggestions, committee. Senator Barlow.
Thank you, Mr. Chairman. So, Mr. Chairman, I'm wondering if the examiner question came up within the work that your folks have been doing with Representative Larson and others, if we want to try to expand the examiner option, i.e. an APRN with forensic training. There's other folks, when I look at the examiner list out of the previous one, there's actually licensed physician assistant with forensic. You could have forensic training as a PA. You could have, APRN. So all I'm asking is, would we like to try to expand the designated examiner definition in some way, which is not in the bill, but we've done that before. Mr. Chairman, thank you.
Representative Larson.
Mr. Chairman, we actually did have that conversation and thought that this was the first step. But I think that that's a warranted, I think everybody would concur that's a warranted discussion that we need to have and would certainly perhaps help provide the services more. But I don't know that I would recommend doing it in this bill at this time.
My vague memory is that we didn't change that all that long ago. I remember when we changed that in Title 25. Yeah, so, yeah, that's, okay. Keep that in the back of your brain, and we'll be talking about it in our committee. Anything further, committee? See nothing, let's go.
Mr. Chairman?
Go ahead, Senator Barlow.
It's effective July 1st. Would you like it effective immediately, Mr. Chairman, for Representative Larson?
That'd be great.
Okay, that's a proposed amendment, line 4, page 3, by Senator Barlow, change it to effective immediately. Any discussion? Taking the vote, all those in favor of Senator Barlow's amendment to change Effective date to immediately, please say aye. Aye. All those opposed say no. That amendment has been adopted. That's the end of the bill. Committee, let's go ahead and take roll call.
Mr.
Oh,
Chairman,
go ahead.
before we do that, I kind of feel bad because this came over here as a non-engrossed bill. It came over here in its original form, and now we're messing it up. So
How bad do you feel?
I don't feel that bad, Mr. Chairman.
Okay, let's go ahead and take vote.
Thank you, Mr. Chairman. House Bill 82, Senator Barlow, Senator Bouchard, Senator Dockstader, Senator Hutchins, and Chairman Baldwin. We have 5 ayes.
Thank you.
That
Those are good
bill
changes.
Okay, now the question is, who's going to present that on the floor? Another call?
Okay, well, I'll work it out with Senator.
You guys can arm wrestle.
I'm not going to arm wrestle her for it. She's
She'd
tough.
win. Okay, that brings us to the conclusion of that. Next, let's go to House Bill 35. Representative Heiner, welcome to the hot seat. Representative Heiner is going to present to us daycare certification requirement amendments, another really, really long bill. Go ahead, sir.
Good morning, Chairman, members of the committee. Pleasure to be here with you this morning and present additional exemptions for home daycare facilities.
Introduce yourself if you would, because online people may not know you.
Thank you very much, Chairman. Scott Heiner, Representative Scott Heiner from House District 18. Mr. Chairman, for many families in Wyoming lack the availability of and access for childcare facilities. It proves to be a barrier for employment, especially for mothers. And in access challenges have forced many parents to change jobs, reduce their hours, or quit altogether. In fact, the Wyoming Department of Family Services reports that between 2017 and 2021, Wyoming lost 89 childcare facilities throughout the state, which is a 13% reduction. While some of these losses occurred in more populous counties like Laramie County, which lost 4%, it was a bigger impact in rural communities and counties. Niobrara, for example, lost 66% of their childcare facilities. Counties such as Bighorn, Fremont, Washakie, Uinta counties, they each lost 30 to 33% of their childcare facilities. So also during 2021, 19% of student parents had to stop their educational progress because they needed to stay at home and care for someone. So, Mr. Chairman, the need is there to provide additional childcare facilities. And it's becoming more and more prominent, especially during the COVID, when there was a lack thereof, and it caused disruption to families that are trying to work and care for their children at the same time. So what this bill does, Mr. Chairman, is it opens up a few more exemptions to the existing childcare rules and regulations to allow families that want to have childcare in their home to have a few more children without being licensed by the Wyoming Department of Family Services and the U.S. Department of Health. So right now, there are a few exemptions to licensure, and I'll go over those briefly. Of course, a legal parent or legal relative's care is exempt from licensure. The second exemption is for occasional care of a neighbor's or friend's child if the person providing the care does not regularly engage in the activity. The third is for parents that exchange care on cooperative basis with no pay. Fourth, care provided by a person employed to come into the home of the child's parent or guardian, similar to a nanny, doesn't need to be licensed. Fifth one is childcare facilities providing care for no more than 2 unrelated children. So very, very small a number. 2 is the limiting factor. And the sixth one is for foster care facilities because they are already supervised by other departments within the state. So, Mr. Chairman, the heart of the bill is on page 2, and I'd like to just go over these additional exemptions. And I appreciate the help of the Wyoming Department of Family Services. They have led me through this path during the last few months and helped me find a spot that would be agreeable to the regulations and helpful for those facilities, that those families that want to have a small childcare facility in their home. What brought this up is there in one of my communities that I represent, it has a population of about 600 people and one childcare facility. That childcare facility has been in operation for 8 years, and they are contemplating shutting down, and there's no other option. And the reason that I was given is because the rules and regulations become quite onerous just for a few children. If that childcare facility goes away, the community will be impacted by that. So, Mr. Chairman, on page 2, I'll go through these exemptions one at a time if it's okay with you. It allows for part-time preschool facilities with 8 minors who are 36 months old or 10 minors who are 48 months old. Now, that's very specific because it has to go into this supervisor-child ratio that's required by regulation. And the youngest child dictates what that category is. If you have most children are 48 months old, but one that is 36 months, then that criteria rules. The second exemption requirement is that they do not administer any medications, because that, of course, has obvious reasons for that. The third one does not prepare food for the minors, and the key word there is prepare. You can still offer food, but you can't prepare it. So the example I like to give is you can give bread and you can give peanut butter, but you can't spread the peanut butter on the bread because that is preparing. So most families will give little snacks, things that do not require preparation. And the reasoning is if you're preparing food, that opens up inspections for the kitchen and things like that. The third requirement is that they have to be potty trained. The fourth limits the minors to no more than 10 hours of preschool attendance each week. And that still, we have guidelines we have to stay within, and the 10-hour limit. It allows for children to be dropped off before school or after school while their parents are not able to be right there to take care of the kids because they have work obligations. And the last one is that they have to adhere to all applicable health regulations in the community where they live. So with that, Mr. Chairman, I'm available for questions from the committee, and I'm grateful for the Department of Workforce Services here that are able to answer the tough questions.
Oh, you get the tough questions first. Questions, committee. Senator Barlow.
Thank you, Mr. Chairman. So thank you, Representative Heiner. This goes under child caring facilities, and their department will get to respond to this too, but this is actually very specific to preschool facilities. So what is a preschool facility in the context of this statute? Mr. Chairman.
Director.
Good morning, Mr. Chairman, members of the committee. I'm Corin Schmidt. I'm the Director of the Department of Family Services. From a child care licensing standpoint, we do not have a designation called preschool. We license all of the facilities under this statute. How we license, though, depends on number of children, and then we designate that way. So five children and under, 10 children and under is a home child care. 15 and under is 15 kids and under the number is a family child care center. Anything over 15 then is a child care facility. So we don't designate by the type of service that's provided, more so by the number of children that are there. So when we carve out preschools in here, what is happening a little bit is that there's a definition being created and saying that for those facilities that serve this number of children or less and do not provide any of the services listed in the on page 2, then they do not have to be licensed, which means that we will not regulate them in any way.
Just a quick question to go with that. When you give 18, 15, 10, Is that an average number, or is that, how do you determine that number? Say if they see 12 on Wednesday, they see 20 on Thursday, how do you determine that number?
Mr. Chairman, it's maintained at that high level, so you can't exceed. So at any given time, you can't exceed 15, 10, et cetera.
Further questions, committee? For any of these folks? I promise Representative Heiner a tough one. Give him a tough one, Senator Doxey.
Well, this is for the director. Representative Heiner opened up seeing the need and perhaps more in our really small areas. Director, are you hearing that as you crisscross the state? The same similar problems? Are we got a gap, a situation for our small rural communities that needs to be fixed?
Director.
Mr. Chairman, Senator Dockstader, yes, across the board, there is need. Child care facilities are very difficult to run. There's certainly a certain number of kids in any given community, so sometimes there just isn't the economy of scale, and the profit margin's fairly narrow. So yes, there's been a need for some time.
Further questions, committee? Just one question that I brought up, I discussed with the representative earlier, and that is a question brought to me, if there's any sort of requirement for things like CPR training or notification that they don't, but if there's no license, I assume that that is not in place.
Mr. Chairman, no, if they're exempt, which means that other than what's listed in the statute, then that's what would be required. There is a provision for rulemaking, but that again, if we encounter a facility that is not licensed, so they don't meet any of these exemptions, what we do is go in and investigate. So we may get a report. We got 50 reports in 2019 on childcare facilities that weren't licensed. We go in and investigate. If we find that's true, then we refer it to the county attorney's office for prosecution.
Very good. Further questions, committee? Senator Barlow.
Thank you, Mr. Chairman. So Section 2 provides rulemaking authority, but if they're not under your auspices, do you need rulemaking authority? Thank you, Mr. Chairman.
Director.
Mr. Chairman, Senator Barlow, where we would use this rulemaking authority, and this is tricky because we don't have authority, but we have authority to make the rules. So we can't necessarily license, but then how do we provide some sort of assurance that the rules, I think, would allow us to promulgate? What we would want to promulgate is something more around safety. So things like background checks, perhaps. That was mentioned in the testimony last week in House Judiciary, where the provider that really had some questions about this service, the provider in a community, and said that they would still expect to have background checks and some safety training. So I think that would be a cue to us we would promulgate that in rule, but the authority to do anything about it still is questionable.
Further questions, committee? Seeing none. Thank you very much. Okay, anyone else here wish to address this topic? Nope, anybody online? Seeing none. Committee, moved by Senator Dockstader to do pass. Stay with us, Representative Heiner, don't run away. Committee, let's go through the bill. Again, rather lengthy and tedious, but let's go line by line or page by page. Page 1, anybody see anything there they want to change or discussion? Page 2. Seeing none. Page 3. Still seeing none. Okay, committee. No questions, no changes. Let's take a vote on the bill. Oh, go ahead, Senator. Thank you. Go ahead, Senator Bouchard.
Thank you, Mr. Chairman. I have the same concerns as Senator Barlow on Section 2. So, I mean, I don't know how we could tighten that up. But
Go ahead, Senator Barlow.
So, Mr. Chairman, I mean, I think I have several outstanding questions which have yet to be satisfied with. One is the preschool question. So is that something that the department would be trying to identify what preschool is in the context of this? Because if they're not providing preschool as some kind of service, it's some kind of an educational program, I would argue. And if that's not being provided, and this is just a care situation, are we getting the exemption that they want? And so, anyway, yeah, I mean, I just have more questions on this than I'm going to get satisfied in this setting. So, anyway, thank you.
Senator Hutchins.
Thank you, Mr. Chair. Representative Heiner, why are the words, or is the word preschool in the bill? Can we strike it and satisfy the good senator? I don't know. What do you think? Is it necessary?
Mr. Chairman, Senator, appreciate the comment. The facilities are utilized more for before and after school, but I think we could change that. I would have to defer to the department if that brings in other rules and regulations, if it's called a daycare. I'm afraid that is over my head, and I apologize for that.
You can throw a lifeline. Come on up, Director Schmidt.
Mr. Chairman, Senator Hutchings, so I think backing up a little bit about what we do regulate in regard to the idea about preschool. So from a child care perspective, we have certain standards that must be met to be licensed. And one of those standards that must be met is to go through a series of trainings. And one of the trainings is in fact on early learning standards. So for any one of our child care centers, facilities, homes, daycare centers, whatever you want to call it, part of the required licensure is some level of training around how do kids learn and what are the developmental stages and how do you engage with them. So with this, if this bill removes this particular type of provider, and we don't have a designation for it, this bill is giving a designation. So what we're doing, what this bill does is it carves out, if you are a provider, you serve how many, 10 kids, 8 kids or less, and you don't do those things. You don't prepare food, you don't change diapers, you don't medications, then you can be unlicensed and unregulated for up to 10 hours a week. So in essence, this bill carves out a kind of provider that we have not previously recognized. There's nothing in the bill that says there must be some educational standard. And I think that's what would create this idea of a preschool. But in terms of our licensure, we are indifferent to what you call it. It's exempting, it's carving it out, it's putting it aside from our 10 and under, 15 and under, and then 16 and above population in a given location.
My question would be on that page 2, the first line. If we were to change that from part-time preschool facilities to part-time child care facilities, does that damage the bill? Does it hurt it? Or I noticed that in the title, it doesn't mention preschool. That's the reason I asked.
Mr. Chairman, I have no problem with that if the department, if it doesn't create any issues with the department.
Oh, it does. It does say preschool in the title. It does. My bad. Yeah.
Yeah, we still can fix that.
Yeah.
I mean, it's like,
Okay.
if we want how this move out and forward, we can fix that real easy.
Okay. Committee suggestions, Senator Barlow.
Mr. Chairman, so I just want to be clear. The way I read the language is it's always going to be fewer than 8 or fewer than 10. And based on the testimony earlier, your cutoffs are actually 10 and 15 and 25, whatever the numbers were for different styles. Am I reading that accurately? So this always falls below that threshold.
Correct. That's correct, Director.
Mr. Chairman, Senator Barlow, correct. I think what this does, what makes this different from a child care center than that has 10 or fewer children, is this limits time. So when we're licensing typically a child care center, they're providing extensive care. They're providing care that starts usually before we work and goes after work. What this particular carve out says, no more than 10 hours a week. So I think that's a little bit how that preschool thinking happens. I think the intent, and I don't want to speak for the bringer of the bill. But I think the intent was, based on the conversations with constituents, was that they have someone who's willing to provide small amounts of care in a kind of a preschool environment that does not exist in that community right now. So it's to fill a gap of what does not exist. This carve out would affect about 12 licensed facilities across the state. So those then licensed facilities would decide whether or not they wanted to continue to be licensed or to fall under this. They would have to be licensed if they want to receive any type of childcare subsidy. And there are other programs that require licensure as well, like the TANF preschool program and some of those others. So if they want to get those funds, they would have to be licensed. So this is the way that we understand this, it would be a very time-limited, small operation.
So, Mr. Chairman,
Senator Doxter.
what do we do with the word preschool? Do we change that? What do we do?
What's your preference?
If it doesn't dismantle the bill, then maybe we need to make it more flexible, all that word. What's the sponsor feel like?
Sponsor, shaking his head, yes.
Mr. Chairman, that would be a friendly amendment if you want to change that from a preschool to a child care facility on line 1 of page 2.
Any comments, discussion of that, Senator Hutchins?
Just quickly, in the title, it says daycare, so can we just make everything daycare instead of preschool, or does it matter?
Well,
Is
the title also
childcare-
says, the title also says childcare, I believe, Senator.
It does?
The very first
Title?
on line 1.
Oh, the act.
Yeah.
Okay, yeah. I'm good with either way.
Senator Bouchard.
Thank you, Mr. Chairman. So the reason why we should really think about this is because whatever we put here is what they're going to hang on their shingle. So the public would expect a certain standard with a preschool. They already expect these standards. So whatever we name here, like, I think daycare is a better choice because that's probably the most limited what we're doing here. This is for like a parent has in the morning, they got an hour where they drop the child off, the bus comes by, picks them up. At the end of the day, there's another hour, the bus drops them off, parent comes and picks them up. So that's what I see this bill doing, basically.
Senator Doxter, your amendment, what do you think?
I'm just looking to the sponsor. He was okay either way, correct?
Representative Reiner?
Mr. Chairman and Senator Dockstetter, I think child care facility would be appropriate naming of that on line 1 of page 2.
Okay.
And it is on the first page. We call it child care facility, so it's no change from the original intent.
Senator Barlow.
Thank you, Mr. Chairman. So as I look through the 14.4.102 in its entirety, all the exemptions, there's actually 2 exemptions that have daycare. One's a daycare agency, and the second one is daycare facilities providing only to immediate family union. So actually, daycare is already used in the statute. Child care facilities is the overarching one. This actually probably fits better as daycare, just by the structure of current statute. Just looking at what is in current statute, the way it's laid out, because this is an exemption. And I think it's hard to exempt something from itself, so you have to actually identify it differently. I wasn't comfortable with preschool, because that's a different title of statute that I was trying to look up. But I am more comfortable with daycare because it's already used in current statute.
Senator Doxter.
Mr. Chairman, let's check again. Sponsor, prime sponsor.
Representative Reiner, what do you think?
Thank you, Mr. Chairman. I appreciate Senator Barlow's reference to 14.4.102. It also references childcare facilities in 14.4.102. A number of places within that exceptions references childcare facilities as well. So I leave it to the prerogative of the committee.
Senator Barlow.
Thank you, Mr. Chairman. So I'm going to move to strike preschool, line 1, page 2, strike preschool and insert daycare.
Okay. Committee discussion, thoughts? There are none. All in favor of Senator Barlow's amendment to change preschool on line 1, page 2 to daycare facilities, all say aye. All opposed, say no.
Just a quick question. We also have it on page 1. Did we want to, good, so I'm an aye.
So that did pass, that amendment passed.
It passed.
Senator Barlow.
Mr. Chairman, to Senator Hutchins' point, there'll be a conforming amendment in the title. Just, and that's, staff will hopefully take care of that, but that's just a conforming amendment.
Correct. Anything else? Did you get that okay, Doreen? Very good. Okay, any other changes, suggestions, committee? Once again, we've taken an engrossed bill and changed it.
Before we leave.
Go ahead.
Senator Barlow, you said you had a myriad of questions, so look, this is the place to do it, not up on the floor.
We can't speak on the floor now, Mr. Chairman?
Well, unless we're setting it up to cause problems on the floor, I'd like to make sure that we handle it here in the committee.
Okay. All right, let's go ahead and call the roll, Doreen.
Thank you, Mr. Chairman. House Bill 35, Senator Barlow.
Aye.
Senator Bouchard.
Aye.
Senator Dockstader.
Aye.
Senator Hutchins. And Chairman Baldwin. We have 5 ayes.
That brings us to our final one for the day. Return Act, we're bringing Representative Larson back. Senator Ellis, would you like to join the representative?
Thank you, Mr. Chairman. So fortunately for this committee, as we get ready to look at House Bill 19, where we create a task force to consider how the state wants to implement an Indian Child Welfare Act laws into state statute, or you've had to some degree discussion in the Senate with Senator Ellis's law, where she brings the existing federal statutes into our state statutes. The issue that we talked about in tribal relations, Mr. Chairman and members of the committee, was even the federal law as it exists, and if we bring it in, still, as we heard testimony in tribal relations from experts on Indian Child Welfare Act, on the Indian Child Welfare Act, we heard that there's probably some components of the act that could stand some adjustment or changes to fit what we do a little better and to better carry out the intent of the act. We know that other states over the course since 1978 have taken the federal act and incorporated some state statutes, and not always to the betterment of the act, but it's kind of been trying to further defend what they felt was an overreach of the federal government into the sovereignty of the states. And so as we look at that, we want to make sure that that we, in an effort to try and protect state statutes, that we aren't making the matters worse overall. And so our thought is that we need to take some time and look at the Indian Child Welfare Act and make some recommendations back to the legislature on possible changes. I think it's important. I think when most of us look at ICWA, we're saying, well, Representative Larson, we get it up there in Fremont County. This is something that you guys are just going to be dealing with most of the time. I'll tell you that in Fremont County, because of the relationship with the tribes having their own law and order code, and then the Department of Family Services having contracts with each tribe's Department of Family Services and how they respond to tribal children who are under are being considered for protective services, most of those go directly to tribal court, which that's the intent really, is to allow the tribes to make these decisions. I think ICWA on a broader scale is, as we see in the federal law in Wyoming, is all of surrounding counties. So if you're in Cheyenne or if you're up in Lincoln County and you have a tribal, an Indian child that is before the courts on protective services or some alike thing, who is ensuring that the child, the tribe's code, jurisdiction, concur, what do we call that? We got to make sure that as that comes to district court, that the tribes are involved. And because there's not a tribal court there. And so it's a huge impact on the state on how we address the placement of children, tribal children, and we have to remember, it's not just Northern Arapaho, Eastern Shoshone. It would be any recognized tribe whose child is here that may be under consideration for protective services. So, and then how do we reach out to their respective tribes to ensure that the placement of this child is in the best interest under the ICWA provisions? So there's it's complex. The ICWA law is complex. I've been reading it for the last year, and of course I have to do that on most everything, read it and then go back and read it again. But I think even if the Supreme Court doesn't do anything, I think the evaluation of the law to determine whether we want to leave it solely as a federal law, bring it into the state statutes, and if so, what changes we think are warranted, is a very valuable exercise that we should consider. So, and I'm pale in comparison to the understanding of this that my co-chairman of tribal relations has been, and she could probably better educate you.
She educates the Senate often. Senator Ellis.
Thank you, Mr. Chairman. I'll be brief. So the ICWA bill that we passed out of the Senate, which will await House action, does create, it mirrors what the federal law requires. There's one provision in there which we would create in our statute if it passed, but it's 14-6-7110. You'll find that in the bill, not in current statute right now. But this would authorize Wyoming through the governor and in consultation with the Department of Family Service to enter into agreements with Indian tribes concerning the care and custody of Indian children. Those agreements could include that those that may provide for the orderly transfer of jurisdiction on a case-by-case basis, and agreements that may provide concurrent jurisdiction between the state and Indian tribes. I think this is one area of ICWA that has been, in Wyoming, we don't look at it a lot, but I think in other states that have larger Native American populations where you do have a lot more ICWA cases, you'll see that almost 10 states have adopted state ICWA laws. But we received testimony from people that study this in depth of how those states tackle those instances. Right now, the contemplation is exclusive jurisdiction. So either the child is just in tribal court or just in state court. But other states have said, this maybe isn't meeting our needs. How do we open that line of communication? And so there are provisions in the federal statute, to my co-chair's point, that if nothing happens at the Supreme Court level, this still is an opportunity for us to look at this law, which we heard concerns, and see if there's a better way of doing things. So, again, I'm not a huge task force fan, but as we talked about this, I do think it would be helpful to have experts brought together, which are outlined in the bill. And then one critique we've heard from one of our tribes is just the format of our legislative hearings. And we know how this works. Your legislators are sitting high on a dais, we're taking testimony. It doesn't have kind of that feel of being really collaborative. So I think this task force has tremendous value in just really putting everyone at the same level and working together, not necessarily in this kind of legislative format that we use. So maybe we could identify some ways of making ICWA work better in general. So it's, I think, a companion bill, an important bill to what we have already discussed with the codification bill. But I, in my mind, have thought about this a lot for the last several months, and I think these two pieces of legislation really could work well together for the mutual benefit of our tribes and for Wyoming. But happy to answer any questions.
Questions for the senator or representative? Senator Schuler, you have, or Schuler, Hutchins, did you have a question?
Yeah. Thank you, Mr. Chair. I see you're creating a select committee on tribal relations. And just not knowing, I was gonna run to the statutes. Is there already a tribal relations committee of some sort out there?
Senator,
Mr. Chairman.
Chairman, yes, and I chair that select committee, and so does
That's-
Senator Representative Larson. And I think it's been in existence for a number of years.
Since Moses left Omaha.
Yeah, it's been around for a long, long time.
Follow-up question, go ahead.
Thank you,
Senator.
Mr. Chair. So if it's already there, what are we really gonna bring here? Are we gonna, because in all the committees I'm on, the senators or the representatives are up here and you're down there. So will this one be crafted differently where we're all sitting around the table and just discussing issues that are different than what the Tribal Relations Committee is doing now?
Senator Ellis.
Chairman and Senator Hutchings, yes, this is different. This would only exist for a couple of years, and it's different than the rest of our hearings. So our Select Committee on Tribal Relations, we look at a broad number of issues, agricultural related. We've had the discussion about brucellosis and insects. We've looked at all kinds of things like trash disposal. And so we tackle a ton of different issues. This would only exist for a certain amount of, a couple of years, and it would bring experts together. Your Select Committee on Tribal Relations historically meets twice a year for two-day meetings. So unlike your standing committees that maybe have 3 or 4 meetings a year that can maybe absorb some of this work, a lot of this work we just couldn't absorb. It would take up our entire interim. So this would be separate, and it would bring those experts together who would be voting members. So task force different than a new committee.
Representative.
And Mr. Chairman, Senator Hutchins, the task force allows you to bring in people outside the legislature to participate, so you can have state agencies, people from the court system, that, as my good co-chairman mentioned, that are just sitting around the table together to identify the issues and make recommendations back. They cannot vote or bring legislation. They come back with a recommendation to do something to move the issue further along or to just eliminate it altogether.
Senator Barlow, you had something?
Thank you, Mr. Chairman. So just as an expectation, do you think this task force, if it becomes a law, would you expect anything to be ready for the next budget session, or do you think it would be the following general session? I see you time it out the middle of 2024, so that's why I'm asking. Do we anticipate there could be something in the next session? Or is it really we're talking about the following general session to now? Thank you, Mr. Chairman.
Mr. Chairman, I think potentially both, but I think it kind of goes back to the health facility task force that for us were involved in, where the first year it was identifying really the anomalies or the gaps, then getting further direction, and maybe that's when you end the task force and create a subcommittee or assign it as an appropriation, then bring it back. But we're just trying to lay the foundation, getting through the information to then bring back something, a more refined recommendation.
Further questions, Senator Bouchard?
Thank you, Mr. Chairman. Where I'm having a little heartburn is we already have a companion bill that went through, and that makes law. And that could go to the Supreme Court, and that is in the Supreme Court's hands. And it was said on the floor that we may have to just do something totally different because of whatever the court decides. And now we're doing it again in another layer. We may have to do something different, even this task force comes to some conclusion. So I'm not getting why the rush to do this now. Why aren't we just waiting for the Supreme Court to make a decision and then come back to the table?
Mr. Chairman.
Representative.
I think that for Senator Bouchard, with the conversations that we've had, we understand the deficiencies that are being argued in front of the Supreme Court. The concern that the Tribal Relations Committee has had is if they overturn ICWA, if ICWA no longer exists, then what's our plan? And we currently, Plan A is we put those federal provisions in there. And if the Supreme Court overturns it, we've kind of got Plan A, but Plan A still has some gaps, some flaws, as my good co-chairman identified. If ICWA is not overturned, those gaps, those issues that lie within the current federal act still exist. And so irregardless of what the Supreme Court does, there's some issues in the Indian Child Welfare Act that the state of Wyoming really ought to address. And this, we're trying to be a little bit proactive rather than reactive, because we know where the gaps are at. If the Supreme Court overturns it, we'll just further act on that. So I don't see, we heard concern on the House side of why don't we wait? And I would only suggest to you that waiting prolongs the ability to correct the problems that we currently know exist.
Senator Barlow.
Thank you, Mr. Chairman. So I guess I'll give you at least my perspective. It's like what we've done with primacy in the DEQ and things. We set up, when we did the nuclear most recently, we set up, this is the ground rules. Wyoming's going to take this over when the feds give us that authority or we don't agree with what they do. So I think they actually couple together nicely, so we can actually, in the end, regardless, excuse me, of what the federal government does through the courts or Congress, in the end, hopefully we'll have the right system that fits Wyoming. And this, I think, puts those two pieces together, a starting place and a process to get there. So that's how I'm going to approach it when I am supportive, the same way we have with any other laws in Wyoming. Thank you, Mr. Chairman.
Chairman?
Senator Ellis.
Mr. Chairman, I'd add one other thing. Years ago, I remember a former legislator who used to chair this committee on the House side. She said, the work we do is like laundry. Sometimes you have the desire to throw it all in the wash and it's all done, but then there's one more thing in the hamper and it builds up again. And so like a lot of things that we work on, it's refining and fine tuning. And so especially in the Labor Committee, I think that, we're looking at this finally. And, this task force might be those extra things that we want to say, okay, we've got the base framework there, but is there something we want to tweak or add to it? So, I love getting the laundry done, but this is a big effort and it's a messy one and it's a painful one. I mean, we did hear and we will hear examples of kids who are being treated horribly. And so I think that's why it is imperative that we really look at it and understand if we could be doing anything better and working with our tribes better, not just our tribes, but, neighboring tribes and whatnot.
Senator Barlow, do you have something?
Mr. Chairman,
About laundry.
Mr. Chairman, I will note that actually there is no report due to the Labor Committee. So we are off the hook if we get this bill out of our hands. It goes to the judiciary and select tribal. Thank you, Mr. Chairman.
Senator Bouchard.
Yeah, Mr. Chairman, thank you. I would just like to say I would feel better if we didn't pass the other law first, and then we would have went to this. So that's where I'm having the problem.
Mr. Chairman? May I
Go ahead,
respond?
Senator Ellis.
I was there months ago. I was completely where you were. The problem is the bridge, if the Supreme Court were to say ICWA is an overreach of the federal power, states have to do it. Another example was that earlier this year, it was well understood in federal Indian law that states had limited jurisdiction on criminal matters for crimes that occur in Indian country. It was well established if you had a non-Indian who hurt an Indian person on a reservation, states had no jurisdiction. Last year, the Supreme Court undid that. It unraveled a major thing that we thought was settled law. And so now the question out there is, well, this case arose in Oklahoma. What about Wyoming? And so people in Wyoming say, well, no, this only applied in Oklahoma. No, Wyoming, that's the question that's outstanding there. Maybe we have this new jurisdiction, but do we want to use it? We don't know. And so even on that matter, there's confusion. What do we do? So the governor has said, the status quo will stay the same. That's our decision. Well, that's neat. But what if you have a Fremont County prosecutor who's like, yeah, I disagree. I'm going to go start prosecuting these cases. So that part's really left unopened. And I think people in my world that study this stuff and follow it, we're all like, okay, uncertainty, this is messy. The reason I brought that is for that exact instance. If IC was overturned as an overreach of federal power, states have to step in. If we don't have this in place, what are we going to do? Do these kids go to state court or do they go to federal court or the tribal court? We don't know. More fights, more uncertainty for kids. So that's why I decided to bring that bill as a separate piece, is so there is no confusion, that we bridge that gap. And then if we want to take a look at it down the road through this task force, that we have a mechanism to do that. But I was with you. I agree with you. But I laid in bed endless nights thinking about this, and I think this is the right path with these two going forward.
Further questions, committee? Seeing none. Director, you have anything to share with us? Oh, Senator Hutchins.
How many members, excuse me, Mr. Chair, thank you, are on the tribal relations now?
Mr. Chairman, Senator Hutchings, 6. There are 3 Senate members, 3 House members. We've included people in the minority party. But this last year, we did have 1 in the minority party on the House side, but we had 3 majority party members on the Senate side.
And if I can
Go ahead.
follow up quickly, you don't see a subcommittee of this committee helping as much as creating a new task force.
Senator Ellis.
Thank you, Mr. Chairman. So I think the state or the Select Committee on Tribal Relations will continue to do all the work that we do, looking at hunting and waste disposal, healthcare, education. We tackle a lot. We really do. This would just exist for a shorter period of time and just look at ICWA, and it would include, our hearings. They're like you've participated in the interim. If someone wants to come, it's at their own cost, right? They have to pay for their hotel if they want to show up and testify in person or take time out of their day to do the Zoom. So what we're trying to do is encourage and allow experts who have the expertise to participate in these all-day meetings and get compensated for it, like we do with other task forces where we bring in the public with members who have expertise. If we did this just in our committee, first it would take up our entire interim. This would be the only thing we'd have time to work on. And then those experts, we'd be asking them to volunteer their time. They might not be as willing to participate. And then we don't have a product that really gets after what we're looking at.
Okay. Director, anything for us? Very good. Okay. Thank you very much. Anyone else in the audience? Come on up. Come on up. It's a long ways from that back row to the front. You better get up here while there's time. And the seats are still warm. Go ahead, sir. Introduce yourself.
Thank you, Mr. Chairman. My name is Travis McNevin here on behalf of Northern Alcohol Business Council. Certainly want to thank Senator Ellis and Representative Larson for all of their efforts on the Tribal Relations Committee. Endorse what has been said here. Both the council views these two efforts as parallel and complementary efforts, both the bill and the task force, particularly as it lays out for the timing of what may or may not happen with the Supreme Court. But by having both of the law codifying ICWA as well as this task force in place, any of the potential outcomes that are possible could be addressed in Wyoming to create a situation where they're addressed in a timely manner and with the least amount of uncertainty as that comes forward. And with that, I'd be happy to take any questions.
Questions, committee? Seeing none. Thank you very much.
Thank you, Mr. Chairman.
Welcome to Labor and Health. Was a long ways up from that back row, wasn't it?
Mr. Chairman, I'm out of breath.
I'll catch your breath and go ahead and introduce yourself and address committee.
Need a moment to compose myself. Mr. Chairman, members of the committee, my name's Kit Wetland. I'm special counsel for Governor Gordon and his tribal relations policy lead. Just in conjunction with Senator Ellis and Representative Larson and the Northern Arapaho tribe, the governor supports this bill as well. He's willing to participate in the appointment process and just be part of this process moving forward. ICWA was important for the state, for the tribes, and it's something he wants to make sure we get right.
Questions, committee? You went a long ways to get here. No questions. Now you got to walk all the way back. Anyone else online or in the audience? No one else? Committee, what's your pleasure? Move the bill by Senator Barlow, do pass. Comments on the bill, committee? Suggestions, amendments? We won't go page by page on this one, but I do notice there's, if this does pass committee, there's an appropriation. It will be going to appropriations. Okay, no comments. Committee, are you ready for the vote? Sensing we're ready.
Thank you, Mr. Chairman. House Bill 19, State Indian Child Welfare, Senator Barlow, Senator Bouchard, Senator Dockstader, Senator Hutchings. Could you repeat that? No. Thank you. And Chairman Baldwin. We have 3 ayes and 2 noes. Who would like to present?
I'll say that so people hear me. House Bill 19, State Indian Child Welfare Act Task Force has passed Labor and Health Committee. Senator Ellis, you will be bringing that to us? I would love you to.
Thank you.
Thank you very much, committee. That's all of our work for the day. We do have 3 bills assigned for Wednesday. We'll get that notice out today. I'll make sure you all have them. We're going to start at 7:30 on Wednesday because at least one of those bills will take a little longer discussion. Okay. So that's the plan, and only one right now for Friday, but I suspect that will change today. Okay, thank you, committee. Good work.